Thank you, Mark, for the excellent presentation. So we're going to start off today, or my presentation, with discussing the Form 8840. And the 8840 is basically if you are taking a closer connection um, exception to the substantial presence test, right? So recall an alien or an individual in the United States who's not a U.S. resident or not a U.S. citizen can become a U.S. tax resident, which means that they're subject to income tax under worldwide income, and they're subject to all the filing requirements, which includes Form 5471s, 8938s, etc., if they wind up satisfying the substantial presence test. And just as a recap, how do you wind up satisfying the substantial presence test? That is, if you're not a U.S. citizen, you're not a U.S. resident, and you're in the United States for at least 31 days in the year, in year one, let's just say, and then over the past couple years, it that year itself, you're in the U.S. for at least 183 days. If you take all the days in the first year, and then you take a third of the days in the second year, and then you take a sixth of the days in the following year, the third year, and that adds up to 183 days. Then you wind up satisfying the substantial presence test. And even if you don't have a green card, even if you're not a U.S. citizen, you can be subject to U.S. tax on your worldwide income, and you could also be subject to U.S. filing requirements. And it happens a lot more than you would think. So there is an exception to the rule, and the exception to the rule is under the closer connection test, right? And basically under the closer connection test, if the individual has a closer connection to another country, then you may be able to kind of back out of the substantial presence test. And Treasury Regulations Section 301.7701B-2D provides a detail of the facts and circumstances that are considered, and I'm not going to go ahead and repeat it because I think Mark went through a pretty good analysis on how you go ahead and apply these facts and circumstances to have a closer connection to another country. But this is the regulation itself that discusses where, if you apply these rules, how you can have a closer connection to another country than the U.S. for purposes of not satisfying the substantial presence test. Now, one important factor here to consider is if you are dealing with an alien and that alien has started the process, the immigration process to become a U.S. resident. They've taken affirmative steps. And what is affirmative steps? Such as you're filing, that individual's filing a form I-508 or form I-485, or they filed any kind of an application for U.S. residency, then even if you satisfy the closer connection test under the Treasury regulations, the facts and circumstances test, or even if you're not in the United States that one particular year for 183 days, you can't use this test to try to break your residency for tax purposes. That's something to keep in mind, and that often winds up happening in our practice. You wind up talking to somebody, and they're like, "Hey, I read on the internet that there is an exception to the substantial presence test. If you look at my facts and circumstances, I have a closer connection to another country than the U.S." And then you kind of start talking to them a little bit more in detail, and then you find out that they've already started the process to become a U.S. resident for tax purposes. So that's an important question to ask. All right, so now let's just say you're dealing with the client who satisfies the substantial presence test, but you want to use the closer connection exception to avoid having them classified as a U.S. tax person. What do? Well, first thing you have to do is you have to file the Form 1040-NR. You have to file the non-resident form. And it's important that in most cases, they're not going to have a U.S. Social Security number. They're going to have a taxpayer identification number. So if you're going to file this form, you need to get that taxpayer identification number, and that's sometimes can take a little while for your client to wind up coming up with that, to have the IRS issue to them that identification number. So 1040-NR, then you have to attach to 1040-NR the form 8840, and we'll go over that in a minute. But when you file that form 1040-NR, you're going to have to include your client's U.S. source taxable income. So what are we trying to do here? We're trying to get the individual who's not a U.S. person to be taxed only on U.S. source income, not on foreign source income, and we're trying to get them to not have to file a bunch of informational returns that could be very expensive and time-consuming for the client. So if they satisfy the close connection test in this case, and it's going to be a little bit different than we're going to talk about a little later on with the treaty tiebreaker position, you could avoid all that. The only sources of income that the individual is going to be taxed on is going to be U.S. source income. All right. So now let's walk through the 8840, where the 8840 is going to be basically, it's an identical discussion to what we just had in this seminar for the past 45 minutes, where it literally walks through each and every single rule or every single factor that the IRS considers in determining whether someone's going to be a U.S. person, have a close connection to the United States, or a closer connection to a foreign country. So the form itself is broken down to several different parts, and let's kind of take a look at part one. So part one is going to be your basic part, and then part one is going to ask the individual to list any U.S. visa issued and entering into the United States. Now, if you have a client that entered into the United States without a visa, then what you should do on line one is basically state the immigration status of the individual on the last day of the tax year. And the date of the U.S. entry should also be entered for line one. Line two, easy, you just ask the individual to state the country or country he or she is a citizen of during the tax year. Line three, ask the individual to state the country or countries that issued that individual a passport during the year. Line four, just state the individual's passport number. Now, line five, ask the individual to list the days present in the United States during the present year and the previous 2 years. So now we're applying the substantial presence test, and you're basically listing the days on the form. And what you don't do is you don't list any days that the individual is not present in the United States. Those days should not be included at all. Line six, ask the individual to state the affirmative steps the individual has taken to become a lawful permanent resident. If you get to line six and you have to state yes, or you're stating the affirmative steps that your client has taken to become a lawful permanent resident, stop preparing the return, stop preparing the 8840, because it's not going to work, because this is an individual, we talked about earlier, who has taken affirmative steps to become a U.S. permanent resident. So can't use the close connection test. All right, now part two. Part two is only completed by an individual claiming a closer connection to one country, one foreign country, should I say, rather than rather than say two foreign countries, because you can use the closer connection test to be claiming that you have a closer connection to more than one foreign country. All right, so only one foreign country, only have to prepare part 2. Now, line 7 asks the individual to state his or her tax home during the tax year. Now, we discussed what tax home was earlier. You have to basically state the tax home during the tax year. Line 8 asks the individual to state the foreign country to which he or she had a closer connection than the United States during the tax year. All right? Now, let's now move on to part 3. Now, part 3, as I indicated earlier, this is completed by an individual who is claiming a closer connection to two foreign countries rather than one foreign country. So line 9 asks the individual to state his or her tax home during the tax year during the current year. Line 10 asks the individual to state a change in his or her tax home during the year at issue. And line 11 asks the individual if he or she had a closer connection to each home listed on lines 9 and 10. If there is not a close connection to either one of those countries, then you're going to have to basically attach a statement to the form itself and discussing why. I can't imagine why you would do that, but that would be the case if you're claiming that there is no close connection to another country. Line 12 asks if the individual was subject to the internal laws of the countries listed on lines 9 and 10. Line 13 asks the individual if he or she filed tax returns listed as the tax home countries in line 9 and 10. Now, sometimes you're going to be dealing with a client that they may not have a tax obligation in their home country. So that's something to kind of consider when you're preparing this, and maybe you may want to provide the IRS with additional information, but we'll talk about that in a minute. Okay, now we move on to part 4 of Form 8840. And part 4, line 14, asks the individual what his or her regular principal home was located in the tax year. So basically have to state there where the principal home was of that individual during the tax year at issue. Line 15 asks the individual to list all homes available during the tax year at issue. So a lot of times when you're dealing with a client in this situation, you're dealing with a client who has homes all over the world. And you're dealing with a client who probably may have a home here in the United States, but has a home in their home country as well, maybe some other countries also. So this is something you need to kind of keep in mind. And what I'm going to say in a minute is that when you go through this form itself and you're checking yes or no, and you're just basically listing answers to certain questions, what sometimes you're gonna have to do is attach additional information to the form itself. Because if the IRS is looking at this form and they're seeing that you have a home here in the United States and a home in a foreign country, what you may want to do is you may want to follow up with an attachment, say, well, it's true I have a home, the client has a home here in the United States, but you may want to go ahead and say what the square footage of that home here in the United States would be compared to the square footage of that home in the home country. Now, that always doesn't work, because sometimes you will be dealing with an individual who may have a home in a vacation spot, right? I don't know, here in California, I've got clients who love to buy homes in the Sierras, in Lake Tahoe or other vacation areas. And maybe their home itself in their home country might be in a city. Let's just say it's in Seoul, South Korea. So you may want to go ahead and have an attachment on there and state, well, yes, there is a home here in the United States. Maybe that home is larger here in the United States than that home in their home country where they have their residence, but it's in a city. It's in a major financial area and so forth. So you definitely, when you're preparing this form itself, want to keep in mind that this is not simply an exercise of just stating yes or no, or just stating certain information on the form itself. This is your chance to advocate for your client. The last thing you want to do is get into a residency audit. We've gone through those here, and I can tell you they are extremely detailed. They're long, and so if you can go ahead and try to nip it in the bud, so to speak, right now when you're completing this form, and give the IRS as much information as possible, so when they read it, they can kind of understand why your client has a closer connection to their home and their connections in the U.S. It's not significant when you're considering the totality of that client's financial picture worldwide. Okay, now with that said, this is where a lot of people wind up having issues. And for line 16, it asks the individual to state where his or her family was located. A lot of times you will have a client who they'll either send their kids to school here in the US, or maybe their spouse might be here in the US. And although they might not be in the US all that often because they're off, conducting their business all over the world, this is where a lot of people, at least in my experience, wind up having issues in trying to claim this closer connection test. So try to find out early as possible when that client comes to visit you and has that initial consultation with you, where the family is, where the children are, where the spouse is. That's a sticking point. Line 17 asks the individual where his or her automobiles are located. A lot of times you're going to have a situation where you're going to have a car here in the US and you're going to have a car in the foreign country. So then when you're preparing this form, you may want to go ahead and look at the values of those cars. You may want to go ahead and list what type of cars you're dealing with. Let's just say, for example, your client has a Jeep here in the US, because let's just say they keep the Jeep here in the US because they like to go up to the mountains, right? But they have a Porsche back in their home country, right? Or another type of luxury vehicle. This is another example where you want to go ahead and you want to start advocating for your client, because if the government looks at this, they look at, and this is, well, you have an automobile in the US. And the next question here for 18 is, where is those automobiles registered? Always ask the client, what type of automobiles are going to be located here, what's going to be located in the foreign country, and the year and the make of the vehicle, obviously. That's gonna definitely come into play when the IRS makes this determination for a closer connection. All right, line 19 asks the individual where his or her personal belongings are located. Yes, artwork is taken into consideration, furniture. All that comes into consideration where you have a closer connection. So, fully furnished home in the US with expensive artwork, or just like, let's just say a bunch of tech gadgets and so forth, or toys, that's not going to bolt over very well, all right? And the problem is, like a lot of type of clients that we run into, they tend to have homes in vacation areas. They tend to really keep a lot of their toys and so forth in their home, and snowmobiles, ATVs, etc. So once again, this gives you the opportunity to advocate for your client. So when personal belongings come into play, they ask this question, IRS asks this question, you want to go ahead and explain what personal belongings are here in the U.S. Compared to what personal belongings might be in the foreign country, and why you may want to have that type of personal belongings here in the U.S. and compared to the personal belongings in the foreign country. All right. Line 20 asked the individual where they conduct their routine personal banking. In my experience, in our experience here at our firm, the type of client that comes to the U.S. that you're going to be maybe dealing with, unless it's like an oddball year, they're going to have banking in the U.S. and banking in their home country as well. All right. So what you're going to have to do, and when you're completing this type of form, is try to advocate where the vast majority of their financial assets that have value are located, right? So let's just say their life insurance. Their life insurance is a really big deal outside the United States. I mean, we have it here too, but life insurance outside the U.S. tends to utilize a contract, which is almost like a savings account, right? And there can be substantial sums of money in that. You could have a lot of investment accounts and so forth. So let's just say here in the U.S. there is some money, but that money itself is not much compared to what's outside the U.S. That once again is going to give you that opportunity to kind of go ahead and prepare that argument for your client. Line 21 asks where the individual is conducting business activities, and if it's outside the tax home. All right. So where you're going to wind up having difficulties with this if you have someone who's from outside the U.S. and they're actually running a business in the U.S. That could be a problem. Line 22A asks the individual where his or her driver's license was issued. A lot of times you're going to have clients have multiple driver's licenses. That's not unusual. So I think back when the IRS issued the guidance regarding driver's licenses, they weren't really considering that you could have an individual having a driver's license in the U.S. and outside the U.S. So once again, you definitely want to probably go ahead and have an attachment to this form if you're dealing with somebody who has multiple driver's licenses in multiple jurisdictions. Then line 22B asks where that second driver's license was issued, which kind of takes into consideration an individual who may have a driver's license in more than one country. Line 23 asks where the individual is registered to vote. At least in my experience, the problem is sometimes you get a lot of individuals who are just not that into the politics, and they may not have registered to vote, in their home country. So it's something to kind of ask your client about, but that may not be as determinative as it may have been once. But regardless, line 24 asks the individual if she or she has completed official documentations or forms establishing residency. So once again, residency in the U.S., if you have a client who started going down that road, you're wasting your time going through this exercise. However, if you're dealing with somebody who's claiming a tax home in a foreign country, but yet they haven't even established the residency by completing the forms necessary to establish residency, that could be a problem. Line 25 asks if the individual completed a Form W-8 W-9, or any other U.S. official forms. As was talked about earlier, if you have someone who's basically acting as if they were a U.S. person for purposes of receiving streams of income, either through wages or passive income, that could be a problem. That is one thing that's also considered. Line 26 asks the individual what country or countries she keeps her personal and financial and legal documents. Again, where's the will? Where is the vast majority of the financial documents and personal documents? That is an important factor to determine purposes of where you assign residency for the closer connection test. Line 28 asks if the individual has any U.S. source income and if it's reported on the form 1040 NR. So if you have a client that has received U.S. source income, make sure that that U.S. source income matches up with the 1040 NR and was being reported on the 8840. You don't want to have a situation where the two don't match. All right, line 29 asks the individual what country or countries his or her investments are located. I think we kind of touched upon that earlier. And line 30 asks the individual if he or she qualifies for a national health plan sponsored by a foreign country. Well, I could tell you a lot of times I'll have a client come to me before we even had this conversation, and they knew about the closer connection test, and the very first thing they asked me is, well, hey, can you assist us in getting a cheaper health insurance plan in the U.S.? That's not a good question to be asking if you're trying to go ahead and use the close connection test. Now, with that said, you may have a situation where this individual is maybe in the U.S. for a shorter period of time, and yet they want to make sure that they're covered in the U.S. But if they are seeking insurance in the U.S., health insurance, or they have health insurance in the U.S., make sure that they also have health insurance, or they're covered by health insurance in their home country. Right? That's very important. All right, so now let's move on past the closer connection test and the substantial presence test, and now let's talk about the treaties. All right, let's talk about the treaty tiebreaker. All right. Before we get into this, I'm going to give a couple warnings about using a treaty tiebreaker. All right. And first of all, what is a treaty tiebreaker? Well, a treaty tiebreaker is something similar to the closer connection test as far as tests go, where you could have an individual that basically is treated as a non-resident for tax purposes. All right. So by being treated as a non-resident for tax purposes, what does it allow? It allows an exclusion from being taxed if an individual can take a treaty tiebreaker position, and they can, under a treaty, be taxed. Let me back up. That is, basically what you're saying is that that individual has, similar to what we were talking about earlier, a closer connection to a residency in a foreign country than the U.S., and under a treaty tiebreaker provision, instead of a closer connection to a foreign country than the U.S., then they are taxed as if they were a resident of a foreign country. Now, it's a little different than the closer connection test for the substantial presence test, because although you wind up avoiding taxation on foreign source income, unlike the closer connection test or the closer connection test, this does not absolve the individual of their U.S. filing requirements. So let's just say they have foreign corporations. They still have to file the Form 5471. Now, it is an abbreviated version of it, but they still have to file it. They will be able to exclude guilty subpart F income, which is good, but that Form 5471 still has to be filed. Gift tax returns still have to be filed as well. Okay, so who can utilize a treaty tiebreaker provision? Well, I've indicated earlier that this is somebody who we could use a treaty, have a closer connection to a foreign country. So who can that be? Well, that could be anybody who can qualify for this if they can be classified as a U.S. resident alien under Section 7701B. So that includes your green card holder. That includes someone who meets a substantial presence test, or someone who makes a first-year election to be treated as a U.S. resident. But you, when you are doing this, look at the treaty itself well, before I go any further with this, if you're going to go ahead and take a treaty tiebreaker position, understand that the political winds have changed a lot in the past few months, okay? Now, in the past, I've done a lot of treaty tiebreaker provisions for individuals. If you're dealing with someone who's a green card holder, right, and they're saying that they're a U.S. resident under U.S. immigration law, right, and now you're turning around, and this gets me to one of my first warnings, and you're turning around and you're saying that on your tax returns that you're not a U.S. person, you understand that that could have immigration consequences. Like I said, I've been doing this for years. I've never seen any kind of issues coming up with the immigration authorities, but that might change now. So when you're advising your client regarding a treaty, taking a treaty position and saying that they have a closer connection to a foreign country, and yet they have a green card, understand that this could have consequences. So it's always best to consult with an immigration attorney, more so now than ever, before actually going ahead and taking a treaty tiebreaker provision. All right. So we always said, who's going to take this? It's pretty much usually going to be a resident alien who satisfies the green card test and who satisfies the substantial presence test. Well, why can't U.S. citizens take it? Because U.S. citizens cannot take a treaty tiebreaker provision. And that's because of savings clause. The vast majority of treaties that the U.S. has entered into, the treaty contains a savings clause. And what does the savings clause do? Well, it kind of prevents U.S. citizens from utilizing a tax treaty for doing much for U.S. tax purposes. Now, it doesn't totally kill off in every single case an ability of a U.S. person. Just getting off topic for a minute here. A U.S. person sometimes can take a treaty position if the savings clause specifically has an exclusion with that specific article in the treaty that may allow for an exclusion of a certain item of foreign source income. What would that be? Well, that would be, in many cases, foreign social security. A lot of treaties allow foreign U.S. citizens who receive foreign social security the ability to avoid U.S. taxation on that social security. Sometimes there's a few treaties that allow for U.S. Retirement type plans, something similar to an IRA or a 401k. Sometimes some treaties like the U.S. treaty with France, income tax treaty with France, or the UK, or the Netherlands, or Belgium, I think Bulgaria, and a few others. That will allow a U.S. citizen, because there's a special exception to the savings clause that allows them to exclude that source of foreign income, or should I say defer that source of foreign income. But as a general rule, the savings clause prevents U.S. citizens from taking a treaty tiebreaker position. All right. Now, let's move on now. So how do we take a treaty tiebreaker provision? And then we'll kind of dive into the nuts and bolts of this thing and how this thing operates, all right? So just like the closer connection test, you're going to go ahead and you're going to file a Form 1040-NR, right? And your client's going to include their U.S. source income. If that client has foreign assets, double check and see if that foreign asset itself has to be included on that Form 1040-NR. Most common case that we see, the client's going to have an interest in like a foreign entity, like a foreign corporation that could be treated as a CFC under one of the CFC rules, and you're going to have to attach probably a more simplified version with fewer schedules on that Form 5471 that's attached to the 1040-NR. The other thing you're going to have to include is the Form 8833. That Form 8833, what do? You basically state on there the sources of income, foreign source income, that you're excluding because of the treaty. So you list each and every single source of foreign income that you want to exclude because of treaty tiebreaker. And then you're going to go ahead and you're going to list the treaty provision itself, the actual, whatever treaty that you're using. You're going to go ahead and look at that residency itself, and that residency itself will basically, you'll state on there that because of a residency, you have a close connection to a foreign country and so forth. So you have to basically have a detailed explanation on that Form 8833 explaining why your client is not a U.S. resident under this treaty and why it is overriding the U.S. Internal Revenue Code as far as taxing that individual on their worldwide income. All right. I think the best way for us to kind of walk through this as a general rule, and this is as a general rule, we're going to kind of utilize the 2016 U.S. Model Income Tax Treaty as a model here, and we'll use Article 4-3, which kind of discusses how the treaty tiebreaker provisions work. But understand that this is just a model. Whenever you're actually using this for your client, always look at that specific treaty itself. Each and every single treaty itself is different, and we'll get to that in a minute, why each and every single treaty itself is different. And just because you have a treaty in place does not mean that you're able to use the treaty tiebreaker. All right, so a lot of this, as we walk through this, is almost identical to what we just talked about for the closer connection test for purposes of the substantial presence test. All right, so for purposes of determining residency of a contracting state, which is the two countries that are involved here, you're going to look at, and let me just stop a minute there. When I say residency, a lot of times when you're applying this, and when we'll get to this, and when I go through the specific treaties itself in a minute, that term residency has different meanings under the local law in that foreign country. So you either may want to get yourself local counsel involved when you're dealing with this, or you definitely want to know what that residency is of that foreign individual when you're utilizing a treaty tiebreaker provision, because we here in the U.S. we tend to think of residency in a certain way. Residency is not always defined the same way around the world. All right, so for purposes of determining residency, here's what's looked at. Permanent home, sounds familiar, huh? Center of vital interests, habitual abode, citizenship. You're dealing here with someone, so I'm not really going to dive into this. You're dealing with someone who's not a U.S. citizen, all right? But anyway, according to the model treaty, it's used. And then finally, mutual agreement by competent authorities. I don't know how many of you have dealt with a competent authority. What is a competent authority? When you can't come to a resolution and you cannot come to a determination of where someone is a resident, then it goes to the competent authorities. The competent authorities are the taxing agencies of the two countries involved. In this case, it'd be the Internal Revenue Service and the foreign country. And you basically ask the two of them to make a determination of where this individual itself is going to be a resident. That actually involves drafting a brief to the Internal Revenue Service and asking the Internal Revenue Service to get involved. I have not done this in the context of an income tax treaty. I have done this, and my my firm has done this in the context of an estate and gift tax treaty, right? Where it's a little bit different, but it comes into play a lot, where someone winds up dying in a foreign country or so forth, and then you wind up having to determine where someone's domiciled. But anyway, it's not important. So, what is a permanent home for purposes of the model treaty? Well, a permanent home for purposes of the model treaty is a purchased home, where the individual intends to reside at that home for an indefinite period. That individual actually did reside in the home. Now, a permanent home can also be in a foreign country if the individual had a room or an apartment that was continuously available. It doesn't have to be a purchased home. The individual had physical property, such as an automobile, personal belongings, stored in that dwelling, in that home outside the U.S. That individual conducted business, such as maintaining an office, including had an address, had insurance, and a driver's license, etc., in that foreign country. That is establishing a permanent home for purposes of the treaty. Now, certain treaties, which we'll get to in a minute if we have time, that will include, it takes in consideration where that individual's family may be. So where the individual's family resides, where the individual's children are enrolled in school is considered for purposes of establishing a home. All right, now let's just say we have a situation like we discussed earlier in the closer connection test, where you have a home in both countries. You have a home in the US, you have a home in a foreign country. What do? Well, think of the way that we apply a treaty tiebreaker test in a hierarchy. So if we can't go ahead and resolve it with the permanent home, the next way we kind of look at it is we look at the center of vital interest test, right? That center of vital interest test is basically going to look at the individual's personal and economic relations, where the individual's personal economic relations are closer. What country are they closer to? And that's how you establish whether or not you have a closer connection to, for purposes of treaty tiebreaker, to one country or next. So that looks at permanent personal relations as to where the family is located. This includes parents and siblings. Believe it or not, according to the model treaty, it even considers where the individual spent his or her childhood. You look at the location of an individual's medical, dental professionals, and health insurance. That's considered. You look at the location of the driver's license and vehicle registration we discussed earlier. Look at health club memberships. Well, unfortunately, a lot of clients don't have health club memberships, but anyway, it's considered. If your client has a health club membership in a foreign country, you're trying to take a treaty tiebreaker position with, great, use it. Where that individual's political and cultural activities are located, that's considered. Ownership of an individual's bank accounts are considered. Where an individual keeps his business and investments are considered. Where an individual has incorporated his or her business is considered. Now, this is a little uncomfortable one for us as tax professionals, but we kind of have to keep this in mind. Where an individual retains professional advisors such as attorneys, agents, and accountants. So keep that in mind. If you're assisting your client with this, your actual assistance of your client to take a treaty tiebreaker position, even taking a closer connection test, is considered. And that's a conversation you should have with the client early on. I've never seen it, basically come to that that winds up being the factor which kind of knocks it over the edge, and they become a U.S. person or a U.S. resident, either under the treaty tiebreaker test or under the close connection test. But nonetheless, if the IRS audits this, and you're representing the client in the audit, and documentation comes out and from the IRS asking for certain information, and one of those things they ask you about is where's the personal advisors, professional advisors, and you're the professional advisor in the U.S. So you definitely want to have that conversation with your clients so you don't have any unpleasant surprises down the road. Okay. So in addition to the factors that we just discussed, other things that come into mind, which under the tiebreaker provision would be considered personal and community involvement. It's important as well under the center vital interest test. Keep in mind too that even if you've established the center of interest, vital interest in one country under the model treaty, it could shift right back to the U.S. really easy, or it could shift the opposite direction as well. So how does that happen? Executing contracts related to business in a country, that could shift it. So let's just say you are dealing with a client, they satisfy the residency test for purpose of the treaty tiebreaker, and now they're executing contracts here in the U.S., right? They're outside the U.S. They're living their lives, they're conducting business or whatever it is in the U.S., but they're still conducting business here. They're executing contracts here. That could shift it back. Be careful about that. Another thing to take into consideration, a marriage. A marriage itself, if you're dealing with a single client and they wound up being married either here in the U.S. or outside the U.S. in a foreign country, that marriage itself could also be enough to shift that vital interest. Okay, so that's something to keep in mind. Now, if under the center of vital interest, that test itself is unclear and there's no permanent home in either country, then the next test to consider habitual abode. Habitual abode is located where the individual has a greater presence during the year. Habitual abode itself is not determined purely by day counting. For example, the OECD recommends looking at the frequency and duration and regularity of the individual's stay in each country to make that determination. And then finally, as discussed earlier, if you've gone through all these tests, and even after all these tests over here, it's still marginal which country the individual could be under the treaty tiebreaker test. In that case, the competent authority of both countries will make a determination of residency. Okay. So now we've gone through the model treaty. Let's go ahead and kind of walk through a couple examples of treaties. And I don't think it's in the slides, but if anybody's interested in a little bit more detailed write-up to what I'm talking about, including a discussion on specifics of the treaties I'm going to talk about right now, let me know. And I can go ahead and send you a more detailed write-up. So the first one is, let's take a look at the treaty tiebreaker provision contained. And I think I'm getting a notification here that we're about to expire in time. I don't know if that's the case or not, but I guess let me just walk through the treaty tiebreaker position for the U.S.-South Korea treaty. And when you're applying, say, the treaty tiebreaker provision for the U.S.-Korea tax treaty, basically what it is, it's contained in Article 3 Oh, okay. It's contained in Article 3 of the U.S. And once again, this is not in the slides. So Article 3 of the U.S.-Korea Income Tax Treaty applies the treaty tiebreaker. And what the Article 3 provides is that he or she shall be determined a resident of the contracting state in which he maintains his or her permanent home. If he has a permanent home in both contracting states or neither contracting states, he will be determined to be a resident of the contracting state in which his personal and economic relations are closer, which is basically the center of vital interest test that we just discussed. And then number C, if the center of vital interest is in neither contracting state or cannot be determined, it'll be determined by the habitual abode. If the habitual abode is in both contracting states or neither contracting states, then that will be the individual will be determined to be a resident where he or she is a citizen. And then finally, if that cannot be determined, then what will happen is that a mutual agreement will be determined by the competent authorities. Now, remember earlier, I said that, always know your local law. And so this is important when you're dealing with a country like U.S. Korea. The local law itself under Korea defines a resident as an individual where the family is living together, property is situated in Korea, and where that individual stays for a substantial period of time and leads a normal life, which is unlike a domiciliary. So once again, so in the U.S., residency, we don't consider so much family, but in a lot of foreign countries' laws, residency itself also takes into consideration family as well. So always take that into consideration when you're using a treaty tiebreaker provision. So since we're running out of time, I'm going to quickly finish off on one last thing here. Actually, two last things here. No, one last thing. And the last thing is going to be taking a treaty tiebreaker position under the U.S.-China treaty. Under the U.S.-China treaty itself, you don't have a regular treaty tiebreaker provision. A treaty tiebreaker provision itself, it's under the treaty itself, it's kind of determined through an agreement between the taxing agencies, between the competent authorities. So this is one of those treaties, like I mentioned, where you might be thinking, oh, well, hey, look, my client is potentially can use a treaty here because he has connections to China. Not so much. The treaty itself doesn't allow it. And then one final thing which I have to discuss: if you are a green card holder and you are taking a treaty position, look to see if the green card holder itself, how long they've been in the United States. Because if the green card holder has been in the United States more than 8 years and you take a treaty tiebreaker position, what will wind up happening is you could trigger an expatriation. And if you have an expatriation, they could trigger an expatriation tax. That applies to anybody who has worldwide assets of at least $2 million. So if you're considering taking a treaty tiebreaker position, if that individual has been in the U.S. for more than 8 years, be careful. If the individual has been in the U.S. less than 8 years, taking the treaty tiebreaker position itself would stop the clock for purposes of determining whether or not they're going to be a long-term green card holder. It does not trigger an expatriation. And in some certain circumstances, you can go back in time and amend tax returns to take treaty positions in prior years. So something to kind of keep in mind. All right, so with that said, that will conclude my portion of the presentation. I hope you found this informative. If you have any questions, please feel free to email me or contact me. I'll be more than happy to answer them for you.